MOU antara Dewan Sengketa Indonesia dan Stein Sultan Abdurrahman yang kali ini akan diwakilkan oleh Profesor Sabela Gayo, PhD CPM, dan Ibu Ratna Susanti, MH.
The next agenda is signing of Memorandum of Understanding between Indonesia Dispute Board and Stuyvesant that will be delegation by Dr. Ratna Susanti and Profesor Sabela Gayo.
Diharapkan kepada saksi-saksi yang kami panggil, harap maju ke depan untuk mendampingi. Yang pertama ada Eka Ervianti SH.MH, yang kedua Dr. Tri Artanto, dan yang ketiga Rahmat SPD.
Udah ya, langsung next.
Terima kasih kepada Dewan Sengketa Indonesia dan juga Stein Sultan Abdurrahman yang telah melakukan penandatanganan MOU. Baik, kita masuki ke acara selanjutnya, yaitu diskusi panel yang membahas tentang penyelesaian sengketa maritim internasional yang muncul, belajar dari politik praktik-praktik di Hong Kong. Yang pada kali ini akan dipandu oleh narasumber kita, Kapten Lee Hock Chun, yaitu adalah selaku Integral Marine Consultant PTE Ltd atau Director of Hong Kong Maritime Arbitration Group atau HKMAG.
The next agenda is another panel discussion with the theme The Emerging International Maritime Dispute Resolution Learned from Hong Kong Practices that will be delivered by Captain Lee Hock Chun, the Integral Maritime Consultant or the Director of Hong Kong Maritime Arbitration Group.
Pada diskusi panel hari ini akan dipandu oleh rekan kita yaitu Rodiah Tamardiah sebagai moderator. Kepada Rodiah Tamardiah kami persilahkan.
This section will be led by Rodiah Tamardiah. To Rodiah Tamardiah, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. The Honorable, the President of Indonesia Dispute Board Forum, Professor Sabila Gayo, SHMA, PhD, CPL, CPCLE, ACI, RB, CPM, CPRM, CPT, and the Honorable of our keynote speaker, Mr. Captain Lee Fuk Chun, and welcome to today's discussion on Indonesia Dispute Board Forum 2024. My name is Rodeta Mardia, and I'll be your moderator for the next few hours. Before we start, let me quickly go over today's agenda. We'll begin with a brief introduction of our keynote speaker, followed by his presentation about the emerging international maritime dispute resolution learned from Hong Kong practices. And after that, we'll open the floor for questions. Okay, and now let me introduce our keynote speaker, Captain Lee Fuk Chun. He is a consultant to Integral Marine Consultants, Singapore, Topliss and Harding in Hong Kong. Without further ado, I'll hand it over to Captain Lee Fuk Chun for a presentation. For Captain, the time is yours.
Thank you very much. Can you hear me well?
Sorry, Mister, we can't hear your voice clearly.
I was already quite. Are you okay? Is it better now?
Yes, Mister.
Yes, good. Good afternoon.
Good afternoon.
Thank you very much that you can invite me to make a presentation on the emerging maritime dispute resolution practices and learning from the Hong Kong experience. A very warm greeting to you from Hong Kong this afternoon. Well, I wish that I could be there in person, and unfortunately, I'm in Hong Kong, so I couldn't make the way to Indonesia. So we are talking about the dispute resolution, and in particular, we are talking about arbitration. Now, the arbitration that we are referring to refer mainly to international arbitration and not domestic arbitration. Though I must say that domestic arbitration does play a very important part in a big country like Indonesia. But Indonesia is also a big economic power, and it is important for all of us to know more about the practices of international arbitration. When you are talking about international trade, you can't get away from arbitration because you will be trading from different countries with different countries, and dispute will arise. And inevitably, there will be this dispute resolution requirement, whether in mediation or in arbitration. Are you hearing okay?
Okay, Mister, go ahead.
Yeah. So can you put the screen? Can you put my slide on the screen?
Wait a minute, Mister. We're trying to share screen.
Yeah.
Your PPT.
If you not, then I will have to share from my side.
Sorry, Mister, we are trying to share your PPT. Please wait a minute.
Okay. Okay, good.
Can you see the PPT, Mister?
No, I couldn't.
I could. No.
What I can do is I can go off the screen, then I try to share from my side.
We already share your PowerPoint, Mister, but you can't see it. Wait, I'll communicating with the monitor. Wait a minute, Mister. Iya. Sorry, Mister, can you share your PPT by yourself?
Okay, I will go off first and come in again, all right?
Yes, sorry,
Yeah.
Mister.
Yeah, okay, it's okay.
Untuk para audiens, mohon tunggu sebentar. Kami sedang mencoba menghubungi kembali Mr. Captain Lee Fuk Chun.
Hi, good afternoon.
Good afternoon, Mr. Okay.
Yes, so can you see the screen now?
Yes, Mr. We can see
Okay,
it.
let me start. Yeah. Like as I have been sharing, that we got to, if you are involved in international trade, like a big economic power like Indonesia, arbitration, especially international arbitration, is very important for the country. And for that, we have to understand the problem that the world is facing. We need to know the geopolitical situation. Today we live in a world where there is intense competition for influence. And I believe that without me having to mention the country, you know what I mean. And there is also very strong technology preservation. So especially the Western side, in the Western world, they are trying very hard to preserve the technology from losing out to many other Asian or third world countries. We also live in a world where there are strong unilateral sanctions. countries impose sanction on other countries without the UN sanction. And this is the impediment that caused quite a lot of trade friction. And then we have a very highly successful China with very well developed social cohesion, effective governance, highly educated and motivated population, well-developed infrastructure, all-rounded technology power versus a Western world order in decline. And also, there is an alternative, the Belt and Road Initiative new trading system. And this is gaining a lot of popularity and attraction. Seaborne, maritime seaborne trade will face intense competition, but there are also growing opportunities in the movement of bulk cargo, energy, cruise shipping, and container shipping. So, with this changing political and business landscape, Hong Kong has to reboot its direction to meet these future challenging times. I think in countries like Indonesia, Singapore, and every country also have to change and to with the new competition. Now, now what are the challenges faced by Hong Kong or as well as many other countries? I will list out some of it. Now, Hong Kong is a very unique position. For instance, Hong Kong is also trying to gain accession to the RCEP, which is the Economic Comprehensive Economic Partnership. This is to give Hong Kong more opportunities, more venues of trade, other than just only the traditional market. Now, Hong Kong is also a very unique position, as it's a center which is comfortable with China business and commercial model, as well as the Western model of finance and business. So Hong Kong is a city with twin, what they call common model. They are comfortable with the Western model of business, as well as the mainland China business model. So this kind of attraction, this kind of unique position, give Hong Kong a lot of advantages over many other business centers in the world. Yeah. Next, it has a long-term experience as an international logistics center, and it's also a regional legal center. So this is quite a well-known fact, and many people in Asia know this is where the Hong Kong's strength are. Now, over the years, over the 100 years, Hong Kong has built up a lot of business trust between China and ASEAN countries. Many people from ASEAN, they come to Hong Kong for business. They set up the offices here, and they also use Hong Kong as the springboard, to trade with China. So it is a crossroad between the East and West. Now, Hong Kong also has a very strong advantage, and that is it has a very strong tradition of the respect of the rule of law. As you all know, that Hong Kong is for many years under the British rule, so it has developed a very strong common law tradition. But at the same time, it has also built up a lot of Chinese law experience. We know that mainland China is using civil law, just like as Indonesia, Japan, Korea, Taiwan, Vietnam, Thailand. These are all using civil law country, same like Indonesia. But in Hong Kong, it's same like in Malaysia, Singapore, Brunei. They are using the English law system. So Hong Kong is a place where you have a combination of knowledge. Yeah. Now, then the other advantages of Hong Kong is that English language is a business language understood by many people. Yeah, and of course, they are also competent in other languages like Mandarin, Cantonese. At the same time, there are a lot of people here who can understand Bahasa Indonesia well. Even Tagalog also, they also know. Yeah. So that is one of the natural advantage in Hong Kong. Now, everybody in Asia or in different part of the world, they know that Hong Kong is a strong service and communication center. People come here to shop. People come here to establish businesses, open bank account. Yeah, a business is a pro-business environment here. So it's supported by a very good legal infrastructure, which have been developed over nearly 100 years. Yeah, very well established legal infrastructure, and the government and the judicial system in Hong Kong support arbitration. They do not interfere with arbitration. And even mainland China support the arbitration development in Hong Kong and in other cities in China. Then, of course, the cost of engaging legal counsels and arbitrators are reasonable. I would say they are cheap, but they are reasonable. Yeah. And Hong Kong also has no restriction on the participation of foreign arbitrators. In other words, other people from other arbitrators from other jurisdictions can come to Hong Kong to serve as arbitrator if they are being chosen by the party. Then arbitration in Hong Kong also has advantage in the sense that a Hong Kong arbitration tribunal has power to grant interim measures, injunctions. But a London tribunal in an ad hoc arbitration does not have such power. So unless, of course, the parties have expressly agreed to confer such power on the tribunal. But in the Hong Kong context, the Hong Kong tribunal has the power regardless whether they are given this power or not, because it is enshrined in our arbitration ordinance. Now, during the COVID, all of us suffer. Every country in the world have gone through a very difficult time. So during this period of pandemic, many things happen that cause a lot of changes in the economic fabric and also in the legal infrastructure. There were many disputes arising from force majeure or delay clauses in the charter party or shipbuilding repair contracts. There were also significant supply chain disruptions in different parts of the world, leading to shortages, extreme inflation, business failure, food shortages, unemployment, and consequences arising from it. And there were also rising business interruption claims. Many businesses have taken up interruption insurance coverage. So insurers were paying a lot of money due to these business interruptions. Yeah. And also during this pandemic period, the insurance industry were very strong and resilient through the scheme called the work from home scheme. So in other words, during the COVID time, during the pandemic, the insurance industry continued to function, even though they couldn't go to office. So they used the work from home scheme to handle the claims and the underwriting aspect. And fortunately, this happened to enable the international trade to continue. Why? Then I want to mention this. Now, the pandemic that we have experienced is not the last one we are going to face. In fact, many experts predicted there will be more such pandemic and more serious pandemic in future. So as far as we are concerned, we have to learn from the past experience and to see how we can position ourselves, in managing business disruption, damages to the supply chain, etc., etc. Yeah. Now, as far as the arbitration in Hong Kong, today our topic is learning from Hong Kong experience. So I am trying to share with you more about the situation in Hong Kong. And this sharing of knowledge will help you to see in what aspect this can help Indonesia, or where Indonesia can learn from the Hong Kong experience. Yeah. Now, the arbitration scene in Hong Kong is governed by the Arbitration Ordinance, Chapter 609, which came into force in June 2011. Now, this arbitration ordinance is a combination of different of the law, almost similar to the UK Arbitration Act 1996, plus the UNCITRAL model law of United Nations. I'm sure all of you are familiar with this what you call UNCITRAL, which is the United Nations Commission International Trade Law. Yeah. So this UNCITRAL model law is part of the Hong Kong Arbitration Ordinance, which also include many parts of the UK Arbitration Act. So as far as the Hong Kong arbitration is concerned, it is the unified and the self-contained legislative framework which respect party autonomy, and also they limits the court's power of intervention to ensure a cost-effective and efficient resolution of dispute by arbitration. As you all know, the beautiful part of arbitration is that it is a finality. It can be recognized all over the world. The award is supported and governed by the New York Convention, which require members who have signed this convention to recognize the arbitration awards issued by members' country. So this is one of the very important aspects of it. And we cannot allow the local courts to intervene too much into the conduct of arbitration. Therefore, under this arbitration ordinance, it is the desire of the Hong Kong authority to respect arbitration, to support arbitration, and to limit the power of the court to intervene in the conduct of arbitration. Now, this is something very, very important. And Singapore is also another one such example, where the government of the day support arbitration, and also limit the power of the court. So I have also mentioned earlier this about New York Convention. Now, Hong Kong is a party to New York Convention on the recognition and the enforcement of foreign arbitral awards, same as Indonesia. Indonesia is also a party to the New York Convention. Now, specifically, what is the role of the New York Convention? The New York Convention requires member signatory states to recognize the award from signatory members, so that the award can be registered in the local high court for enforcement against the wrongful party. A court judgment, for instance, cannot have that effect. For instance, if a Hong Kong High Court issue a judgment, it cannot be enforced in Indonesia. It cannot be enforced in Japan. But when an arbitration award is issued in Hong Kong, it can be enforced in 180 over countries. So that is the critical difference, of what is called international arbitration. So Hong Kong has also entered into reciprocal arrangement with the mainland and Macau. Now, this is called, I will come back to that later, but Hong Kong got several arbitration bodies, but I want to specifically mention the Hong Kong Maritime Arbitration Group. It is recognized by the Hong Kong government as one of the premier arbitration institutions. So we have our HKMAG terms 2017, and we have also the HKMAG small claim procedure. Now, the HKMAG terms are substantially based on London Maritime Arbitration Association. Now, and those of you in shipping will know, most of the arbitrations, maritime arbitration in the world, in the past has always been handled by LMAA. But over the last 20 over years, more and more cases are coming back to Hong Kong and Singapore. And I hope eventually more cases will come back to other Asian countries. So therefore, the HKMAG terms is one of a very attractive mechanism to use as an arbitration tool. It is modeled after LMAA, so that most of the shipping people will be familiar with it. Because many shipping people are familiar with the LMAA terms. So hence, we have these HKMAG terms, which are very close to LMAA terms, so that users will have familiarity with it. And also in the year 2020, Hong Kong has been included into the BIMCO contract, arbitration clause. Now, what is this BIMCO? This is the Baltic and International Maritime Council. Any one of us who are involved in shipping will know the importance of BIMCO in the design of charter contracts, etc., etc. Now, in the past, BIMCO, which is basically a Western control council, they have two seats of arbitration by default. That is London and New York. But about 8 years ago, they included Singapore. And then in the year 2020, Hong Kong was also added in. So therefore now in the BIMCO charter contract, there are 4 places of arbitration: London, New York, Singapore, Hong Kong. So that is what we ought to what I'm trying to explain to you. Yeah, I suggest that as far as the arbitration in Hong Kong is concerned, it is good to incorporate the HK-MAG arbitration clause in the contract. There are 2 types of versions. One is a long one is a short one. Now the long one is very long. Yeah. So I just read through briefly for you to have a picture of it. This contract shall be governed by and construed in accordance with Hong Kong or English law, and any dispute arising out of or in connection with this contract shall be referred to arbitration in Hong Kong in accordance with the Arbitration Ordinance, Chapter 609, or any statutory reenactment or modification thereof, save to the extent necessary to give effect to the provisions of this clause. Of course, you can delete any part you require. Now then, if no deletion is made, then Hong Kong law shall apply. So in other words, if you didn't delete anything, then Hong Kong law shall apply. Hong Kong law is actually like English law. So the arbitration shall be conducted, in accordance with the HK-MAG terms current at the time when the arbitration proceedings are commenced. The reference shall be to 3 arbitrators. Nothing shall prevent the parties agreeing in writing to vary these provisions to provide for the appointment of a sole arbitrator, and if necessary, for the president of HK-MAG to appoint the sole arbitrator if the parties cannot agree on the appointment. In cases where neither the claim nor any counterclaim exceeds the sum of US $100,000, the arbitration shall be conducted in accordance with the HK-MAG small claims procedure current at the time when the arbitration proceedings are commenced. It's a very long one, right? Yeah, this is a comprehensive long version. Now let's look at the shorter version. Yeah, and this is a simpler one. Arbitration in Hong Kong in accordance with the HK-MAG terms and conditions. Arbitration in Hong Kong in accordance with the HK-MAG terms and HK-MAG small claims procedure, Hong Kong or English law to apply. Okay, now that is a short form. Yeah. Now, then the Chinese government was trying to help to promote Hong Kong, to make Hong Kong arbitration more attractive. So in 1st October 2019, China set up this legislation called Arrangement Concerning Mutual Assistance in Court Order interim measure in aid of arbitration proceedings by the courts of the mainland and of the HKSAR. Now, what is this? Now, in arbitration, quite often, when you have two parties fighting for the case to be resolved, one party may have the evidence being transferred out, or have the assets of the company transferred out. So, to allow China set up this legislation to allow arbitration in Hong Kong, one of the party to apply to the Chinese authority, to the Chinese High Court, to freeze the assets or to preserve the opponent assets that they cannot sell or dispose of. Now, this is a special interim measure that were allowed to practice in Hong Kong by the Chinese government in supporting arbitration in Hong Kong. And which are the Hong Kong body can have the power to order such interim arrangement. They have the HKIAC, the Hong Kong International Arbitration Center, and then you have the Hong Kong Maritime Arbitration Group, and then you have the UMRAH, you have the SCIA, then you have the AALCO, CITEC, ICC. Yeah, these are the few organizations that was empowered by China to issue such interim order. Yeah, so when you have arbitration conducted in Hong Kong, you have the power to propose to apply to the court for the freezing of the assets or the preservation of evidence. Now, if you were to do it in London, if you were to do it in Singapore, you do not have these benefits. Now, I'm referring to cases involving a Chinese party. Now, whether you like it or not, today in most of the arbitrations, you will always involve a Chinese party because they are the biggest economic power in many parts of the world, and they are all over in terms of their business engagement. So this interim measure is very important to support the arbitration in Hong Kong. Yeah. Now we move on. Now, how does this arrangement work? Yeah. So first, before the award is issued, a party can apply to the Intermediate People's Court of China, either in the place of residence of your opponent party, or where the property or evidence is situated. So, for instance, if his property is in Hangzhou, you can go to the Hangzhou Intermediate People's Court, to apply for this interim measure to freeze the asset. So, in the event if you win the arbitration, there is the value of the property to support the result of the arbitration. Yeah. So, what are the interim measures? The interim measures are property preservation, evidence preservation, and conduct preservation. Now, what do you mean by conduct preservation? For instance, if you know that there's some important witness, we want him to be present at the arbitration. We can order him to remain and not to go somewhere else. Yeah. So this is what we call the conduct. Yeah. Yeah. All right. Then next, I want to share with you the types of arbitration in Hong Kong. So we have domestic arbitrations, which are governed by the Hong Kong Ordinance, Chapter 609. But parties can choose whether to follow the default procedures in the ordinance or to adopt institutional arbitration rules. In other words, when we are talking about domestic arbitration, we are referring to the claimants and the respondents are both Hong Kong domicile. So they will automatically come under this arbitration ordinance, chapter 609. But they can elect not to follow this. And they can elect to follow the international arbitration rules. Yeah. So international arbitrations are governed by the UNCITRAL model law as adopted in the arbitration ordinance. Now you have heard me share earlier on about the Hong Kong arbitration ordinance has incorporated the UNCITRAL model law as part of its law. So when you have two parties who are out of Hong Kong, or you have one party from Hong Kong, one party outside Hong Kong, these are all called international arbitrations. And they do not come under the domestic arbitration ordinance, but they come under the UNCITRAL model law, in far as the procedures are concerned. Now, many of us in arbitration, or many parties in arbitration, they always ask, do we have the right of appeal? Now, as far as the domestic arbitration is concerned, a party can only appeal on a question of law. And that is only when permission is given by the court to do so. But this appeal is not easily granted only when the question of law is one of public interest or the decision of the tribunal is open to serious doubt about his integrity, or his fairness, right? But as far as the international arbitrations are concerned, the ground to challenge an international award are very restricted. It's only focusing on the irregularities, procedural irregularities, rather than errors of law. So, if you look at it again, in the domestic arbitration, you can appeal on the question of law, the wrong application of law by the arbitrator. But as far as international award is concerned, there's no right to appeal because of errors of law. But there's only a very limited right of appeal on irregularities. That means we have the misconduct of the arbitrator, unfairness, or maybe the arbitrator has conflict of interest. He may be a director of one of the company involved in this arbitration, for example. Yeah? So you can only appeal on that basis. So as far as Hong Kong is concerned, it is an arbitration-friendly jurisdiction for cross-border dispute. So the government actually encourages more international companies, international parties to come to Hong Kong for the dispute resolution, for cross-border dispute resolution, whether mediation, adjudication, or arbitration. Yeah, so it's one of the first city in Asia to have developed this level of knowledge and experience in international arbitration and mediation. Now, having gone through the fundamentals of the Hong Kong the seat as an arbitration seat, and the advantages, let me share with you what are some of the charter party cases handled in Hong Kong. For charter party, shipping dispute, shipbuilding, contractual dispute. Ship repair, contractual dispute. Sale of goods, contractual disputes. Cross-border trade disputes. Marine insurance related disputes, including freight forwarders liability, reinsurance, mortgagee financing, etc., etc. Non-performance of sale contract, delivery of goods without production of bill of lading, yeah, and the list goes on. So you can see from here that the maritime arbitrations are very, very wide and very complex. So you require a lot of specialist knowledge. You also you require very clear understanding of law. And most of these cases are rested on English law. Now, when you talk about English law, I'm not talking about just the law of England. The English law, actually, you see Singapore, Hong Kong, Malaysian law, they are actually all part of the English legal system. Yeah. So, as far as Indonesia is concerned, or China is concerned, as Indonesia become a major economic power, you will encounter already encounter all these kind of issues, and how to encourage more of these cases to be handled by Indonesian lawyers and arbitrators. Then it is important for lawyers and for arbitrators in Indonesia to know more about the English law. Not just only the theory part of it, but in the use and the exercise of English law, the rights and interests, the different maneuvering. Yeah. So, for instance, in China, China is like Indonesia. The lawyers, they focus on the Chinese law. The Chinese law is the civil law. Same like Japanese law, Korean law, they are all civil law. But if you want to engage in international maritime arbitration, you are dealing with this kind of issues. You have no choice but to deepen your knowledge of English law practices. So today, I want to share with you my personal experience as an arbitrator in Hong Kong. Some 10 to 15 years ago, most of the shipping cases like this in China, they are handled through English lawyer in Hong Kong or elsewhere. But today, most of these cases in China, in their international trade with other countries, are handled by Chinese lawyers who know not only Chinese law, but also English law. Because when you are dealing with such cases, you have to deal with in the English law knowledge. As far as the domestic arbitration, for instance, between ship owner in Indonesia, in Jakarta, or ship owner in Sulawesi, yeah, or parties within Indonesia, you can use the Indonesian law. But as far as international contract, your party who engage in the contract with you, they will not accept Indonesian law or Chinese law. They want use the English law, not because English law is so superior, but because they have more than 300 years of history, where every word, every phrase has been contested, has been explained. like the word due diligence. Yeah, there's legal definition, clear legal definition. So that is the reason why in all the international transactions, they want English law to apply. Okay? I hope I'm clear on that. Yeah. Now then, when we decide where should I have this to be the seat of arbitration, whether it is in Bangkok, in London, in Hong Kong, in Taiwan, in Japan, in Singapore, or in India, or Indonesia, anywhere. These are the factors you must consider. Because you are placing a case before involving a lot of money before the arbitrator. And his knowledge, his experience will determine whether your case is fairly handled or disposed. Therefore, you have to look at whether in that particular jurisdiction you have skilled arbitrators with integrity. In other words, arbitrators cannot be bought. He cannot be corrupted. Now, as an arbitrator, I can tell you the kind of challenges that we face. There are people who come to you and say that if you let me win this case, I will give you more work in future. These are the kind of temptation that we face. And some people are trying to give us gift. Hopefully that our decision will be in their favor. Now, if an arbitrator is open to this kind of corruption, then you defeat the entire purpose of dispute resolution. So when you look at any jurisdiction, whether you have to see whether they have the skilled arbitrators with integrity. And then the next one is the choice of procedure. Whether you are going to adopt the institutional rules or ad hoc procedure. There are many advantages and disadvantages. For maritime arbitration, they prefer the ad hoc procedure. They don't have to follow a very strict guideline, and the guideline will be determined by the party or by the arbitrator. But if you were to follow the HKMAG rules or the HKIAC rules or the SIAC rules, they are very strict procedures. And in the case of HKIAC or SIAC, you have to pay the administer fees. Yeah, but for ad hoc arbit procedure, you don't have to pay that. Next, you have to look at many business people, when they enter into a contract, an international contract, sale contract, they look at generally the terms, the business terms, commercial terms, but they seldom consider what is the law governing the arbitration agreement and procedure. So this is something you have to pay attention to when you enter into a contract. Yeah. So the contract in the agreement, the governing law is must be English law. You cannot put a law which is not very well known, well established to govern the contract. And then you also must make sure you have the proper arbitration rules that govern the conduct of the arbitration. Without that, the entire procedure can be in disarray. Yeah. So another factors you have to consider whether you have experienced transcribers and translator. Now, what do I mean by that? When you go for arbitration, They had to bring in witnesses, material witness or expert witnesses from different countries. And they may speak a language, may not be in English, maybe in Chinese, maybe in Thai, maybe in Bahasa Indonesia. So you must have good translator in that country. So if you have a wrong translator, then the messages will all go wrong. Let me share an example. I was involved in arbitration in London. So the Chinese witness from China was sent to London. And I was sitting with two other arbitrators, the two were European and myself. So the witness in the conduct of the cross-examination, they all spoke in Chinese. So we need a translator to translate the Chinese into English for my two other fellow arbitrators who do not understand Chinese. For me, it's no problem. Now, what happened was, it is so difficult to get a good translator in London. So finally they got a Chinese reporter, a commercial newspaper reporter, to be the translator from Chinese to English. Now, you know that in our professional work, all our words and the descriptions are specialized. So if you have a guy who is an ordinary journalist, his or her knowledge of the Chinese is purely at the commercial or journalistic level, but not at a technical level. But you depend on her to translate the information to be understood by the arbitrator. If the arbitrator did not get the right message, his decision will be wrong. Understand? So this is important, the translator, not just arbitrator. And then you also need transcriber. Now, in the course and the conduct of the hearing, the things move very fast. The lawyers speak very fast. The cross-examination process is very fast. And you have experienced transcriber who type everything into a transcript, and they give you within the same day or the next day, so that the arbitrator can quickly read the text to see where and who say what and where have gone wrong. Now, I was involved in one arbitration in London, whereby the lawyers and the witness and the QC, the Queen's Counsel in those days, now called King's Counsel, they all spoke very fast, and I couldn't really understand it. So I was following through the transcripts. It was the same night transcript that enabled me to pick out where I may have missed out. So this is very important. So if you don't have good transcriber, then a lot of things will be in a disadvantaged position. Then finally, these are not all, but these are the important ones. You must have competent and knowledgeable lawyers in the specific professional area. For instance, if a lawyer is only good at handling sales of property, and you ask him to deal with a case in maritime handling, which requires specialized knowledge, it is something out of his depth. Therefore, not every country has a pool of competent and knowledgeable lawyer in the specific area. So many lawyers are involved in criminal matters, family dispute, property transactions, investment contract, in the country, but not many lawyers are competent in the full array of international commercial requirements. So therefore, so when we choose a place to be the seat of arbitration, to decide on a case that can benefit you or put you in big trouble for many years because it involves large sum of money, you have to look at all these factors. Not only just arbitrator, but you have good lawyers, knowledgeable lawyers, good governing law, experienced translator, experienced transcriber. Then the physical building is not so important. You can have very nice building, very nice chamber. Well, it is helpful in some way, but it's really not entirely critical. I would consider these issues more critical to you than just the choice of having some very comfortable building. So in an arbitration in Hong Kong, who are the people you will see in the hearing? You will see the parties, that means the representative, from the claimants, from the respondent. In court, you can call it the plaintiff and the defendant. Then you will see the arbitration tribunal, the arbitrators. Then you will see material witness, who have been called to testify. Then you also see expert witness. Now then you will also see, beside the lawyer, the counsel. Now who are the counsel? These are the people who are specialized in argument in court or before the arbitration. So the counsel is supported by solicitors, the lawyers, and their associates. So sometimes when we have a hearing, the party is represented by a senior counsel, 2 solicitors, 2 or 3 associates, and 1 or 2 trainees, bringing along with all the documents. So this is what we normally see. And then you will also see translator, you will see transcriber. So that's what some picture of where we are. Right? Now then we next look at what is an arbitration agreement. This arbitration agreement in the contract is in writing to refer the present dispute or future dispute to arbitration. And the arbitration clause in any contract has a separate assistant from the underlying contract. Suppose if the contract you enter into between party A and B, and subsequently they found that this contract is invalid, but the arbitration agreement in the contract will stand alone in a separate assistant. Even though the contract is invalid, but the arbitration agreement is valid. Okay? So the agreement, sometimes they specify ad hoc arbitration. Sometimes they mention interinstitutional arbitration. So what are the general terms you see in an arbitration agreement? You will see that both parties agree to submit future or present disputes to arbitration. It will also specify the number of arbitrators. It will also specify the appointing authority, if any. It will also specify the place of arbitration, then the rules applicable for the arbitration, then the governing law of the contract, and lastly, language. Now, you may ask, why language? You will find that in many of the dispute cases, the language is so important. For instance, if you have a case, a dispute with a party in Africa, and then they put on there in the contract the language, one of the African language. How can you present your case in that language? How many lawyers can speak in that language? Yeah. So that is why we always put down there the language to be used in arbitration must be clear to avoid future dispute. Yeah. Okay. Now, I have come to the end of this presentation. And if you have any questions, I am happy to share further with you. Thank you so much.
Thank you, Captain, for the informative presentation.
Yeah, most welcome.
Okay, without further ado, it's time to open the floor for questions. We only open 2 questions and you have 1 minute to ask. For the audience, if you have a question, you can raise your hand and wait for the microphone to reach you. Oh ya, kepada audiens silahkan untuk bertanya. Kita hanya membuka 2 sesi pertanyaan dan kalian dan audiens memiliki waktu 1 menit untuk bertanya. Terima kasih. Oke, please raise your, ya silahkan. Untuk MC tolong mikrofonnya.
Tes.
Okay. Assalamualaikum warahmatullahi wabarakatuh. So, good afternoon, Mr. My name is Nabila Zazkia Zikra Alexa, and usually my friends call me Abil. And previously, I was very grateful for your explanations. They're so perfect, so nice. And permission to ask, sir. Permission to ask, sir.
Sure.
When there are problems between China and ASEAN countries, will the diplomatic problems affect some of the agreements of Hong Kong Maritime Arbitrations Group? If so, what solutions will Hong Kong Maritime Arbitrations Group take, considering that the diplomatic problems between the 2 influential countries are serious problems? Thank you.
Thank you for your question.
Please give an applause.
Interesting question. Yeah, I may not be able to answer completely, but I try my best. Now, I do not fully understand what you meant by the diplomatic problem between China and ASEAN. As far as I know, China and ASEAN has a very good, sound relationship. And arbitration does not deal with political issues. So if there is any territorial dispute, for instance, we cannot use the HKMAG or the HKIAC or the SIAC or the SCMA to deal with political problems. Arbitration is only dealing with commercial dispute, contractual dispute in the conduct of business, in the buying of selling of goods, in the buying and selling of services, in investment, in banking, in financing, in transaction, but never in politics. The arbitrator also have no power to deal with criminal matter. We have no right to impose punishment on a person. We can't send anybody to jail, for instance. Yeah. So if we are talking about a diplomatic problem, like for instance between China and Philippines in the South China Sea, I mean, I'm being quite straightforward in that, right? You cannot do arbitration. It will be done by some international mediator, when both parties must agree, and then they come to, even in the International Court of Justice, they do not have the jurisdiction unless both parties agree. Yeah. So when come to diplomatic issues, I think the best to deal with third agency, intermediary, but not in commercial arbitration. So I'm grateful you asked this question so that I can clarify. So arbitration is not the end all or the all. Yeah. Okay. I hope I've answered you. Yeah.
For your answer.
Thank you. Thank you.
I think one more question from the audience. Please.
Please feel free to ask. Yeah, because we all learn together. Yeah.
There is one more question, Mr. from Professor Sabila Gayo.
Yeah.
Hello, good afternoon, Captain Lee.
Hi.
Nice.
Good afternoon to you.
How are you? Nice to see you.
Yeah.
Okay.
Yes.
I hope that.
Good to see you.
Okay. I hope that you are in a good position there, a good situation.
Yeah, yes.
I think there are two questions from our side. The first
Yes.
about how if we do mediation in Indonesia and then a mediated agreement, whether can we enforce or can we transfer to HKMAG arbitration procedure and then how we can enforce, how Hong Kong law can recognize the mediated agreement as an arbitral award, as an foreign arbitral award, because mediated in Indonesia, we agreed a few things, and then because of the asset in Hong Kong or mainland of China,
Mainland China.
yeah, so we bring our mediated agreement to Hong Kong, to HKMAG, and then can you recognize, or can you recognize our mediated agreement as an arbitral award, so it can be enforced in Hong Kong and mainland China? It is the first question, and then the second one is about ODR, online dispute resolution, whether HKMAG you have an access for complainant to file and also to attend the arbitration proceeding by online dispute resolutions, because I think Jakarta or Batam and Bali or some other areas in Indonesia are quite very far away from Hong Kong. I think it takes around 4.5 hours by flight from Jakarta to Hong Kong. So do you have an online dispute resolution platform that if any dispute, so we can file the case through online platform, and then the proceeding also can be conducted, can be organized by online or virtual? Because in some cases we have handled a few complaints from shipmen associations in Tegal, Central Java, because they supply ship workers to some China companies, and then they have signed a contract, and then the contract says if any dispute arises, so they will bring the dispute to international Beijing Maritime Arbitration Center in Beijing. So I think it is very difficult for the shipmen, for the ship workers in Indonesia. If any dispute, sometimes the salary the salary is delayed, and then they don't have other rights as ship workers. So it is very difficult for the outsourcing company in Indonesia to file the case to Beijing, to International Beijing Maritime Arbitration Center. So if any online dispute resolution, I think it will be better and will enable us to file the case and to attend the proceeding in the future. Thank you very much, Captain Lee. Thank you.
Thank you. Thank you. For two questions. As usual, I hope I can provide some answer. The first one I deal with mediation. Now, as far as Hong Kong and Singapore are concerned, when they have a mediation, there's nothing to stop for them to turn the mediation into an arbitration agreement, into an arbitration award, so that it has the force of law. It can be enforced. Yeah. But the situation that you mentioned is something we need to examine closer. I don't have an answer. Where the mediation was done in Indonesia, and then you come to Hong Kong to enforce, to turn into arbitration award in Hong Kong, and for that to have the enforcement, the power and the law of enforcement. Now that is something we have not really come across, but it is really worth considering, because if it is a national mediation, if it's done in Hong Kong, to turn into an award, not a problem. But if the mediation is in Indonesia and then come to Hong Kong to make into an award, then I think we need closer examination. I think we will bring up and discuss on this point. Quite interesting. Then on the second question, I will have to state from the onset that in your agreement, the crewing agreement, is specifically mentioned that the mediation should be done by the Beijing Center. So if you were to do through Hong Kong, unless both parties agree, I don't see how you can change that. So unless the Chinese party and your party both agree to go through Hong Kong, then it can be done. Yeah. And as far as the online platform, you raise a good point. Now in Hong Kong, we have what we call the eBram. I don't know whether you have heard about that. The electronic digital platform for arbitration, which the Hong Kong government has set up with a lot of capital invested in it. So on that platform, the submissions, the hearing, all can be done through online. And there's nothing to stop you from using that platform, but to apply the HKMAG rules, So that is what I can recommend you.
Thank you, Mr. for your answer. Because the time is almost over, I think that's all for our session today. Thank you for your participation and valuable knowledge that you have shared to us. And before we closing, please give an applause once again to Captain Lee Fuk-chun as our keynote speaker.
Thank you.
And
Thank
for
you.
the audience, was invited to come forward and take a photo as documentation together with Captain Lee Fuk-chun. Please. Kepada para hadirin dipersilahkan untuk maju ke depan untuk mengambil sesi dokumentasi bersama Kapten Lee Fuk Chun. Sebelah. Untuk sisanya mungkin bisa di depan Profesor Sabila Gayo kalau bisa tidak kelihatan di kamera. Untuk sesi dokumentasi selanjutnya, silakan dari stand SAR harap maju ke depan untuk sesi dokumentasi.
Thank you very much, Captain Lee. Thank you very
Kepada
much
Kakak
for
Stainsar.
your attendance and
Yeah.
you have shared your knowledge and skills. Thank you very much, and I hope that we can do something together, collaboration in the
Yes.
future. Thank you.
Yeah, thank you so much.
All right, thank you. Keep in contact.
Thank you for your. Yeah, bye bye. Take care.
Bye bye. Take care. Have a nice day.
Bye.
Bye.
Yes.
Terima kasih kepada moderator yang telah memandu jalannya pembahasan dengan sangat baik. Dan juga kami ucapkan kepada terima kasih sebanyak-banyaknya kepada narasumber yang telah memberikan pembahasan yang amat sangat luar biasa.
Thanks to Rodia for leading this section, and also we want to say big thanks to Captain Lee for your wonderful presentation.
Dengan berakhirnya kegiatan diskusi panel kita, maka berakhir pula lah kegiatan kita dari pagi hingga saat ini.
So, by the end of this section, it is the end of our agenda on this day.
Di tepi laut ada barongsai, nikmat lihatnya sampai terlupa.
Acara kita telah selesai. Terima kasih dan sampai jumpa.
Saya Muhammad Heldi.
Dan saya Elvira Clarista Faikah, pamit undur diri sebagai pembawa acara pada acara kali ini.
Jika ada salah ataupun kilaf dalam perkataan kami sebagai pembawa acara mohon maaf yang sebesar-besarnya. Kami akhiri dengan wassalamualaikum warahmatullahi wabarakatuh.